Morning. Welcome to this session of oral argument of the 5th District Court of Appeals. It's certainly our pleasure to preside over the cases on the docket today. Let me introduce the panel. As you've heard, I'm Judge Sawaya. Seated to my right is Judge Rand Wallace, and to my left, we're certainly pleased and grateful to have the help of Judge Bruce Jacobus, who is now a senior judge, and he's graciously agreed to come back and help us with the docket today. We'll take the cases in the order presented on the docket. We've got one criminal case. Time allotted will be 15 minutes per side. The other cases are civil cases, and each side will be allotted 20 minutes per side. We have a clock on the podium that will assist you in keeping time. If the appellant wishes to reserve any time for rebuttal, just let me know, and I'll try and assist you with that. The first case on the docket is Ramirez v. State. Morning.
Samantha Johnson on behalf of Mr. Zens this morning.
Okay.
Should I approach the podium?
Yes.
I would like to reserve 5 minutes of rebuttal.
Okay.
Your Honors, to simplify what we're here for today is, on behalf of Javier Ramirez, we're looking at a difference of 2 days. And the question is, why? In the lower tribunal, the judge did not believe that he had the discretion to downward depart. And that is the issue in the instant case here, is whether or not the lower tribunal had the ability.
But it seems like the trial judge didn't think he had a basis for downward departure because he made a finding that it wasn't an isolated incident. He made a factual finding, didn't he?
I don't believe so, Your Honor. I believe
He kept saying this is not an isolated incident. You know, he said it happened there's a dispute about how many times, but it was over a year, and it was, I think at one point, your client said maybe 10 times, but maybe, it was receding from that. But it seems to me, it was clear the judge said it's not an isolated incident. He said it about 4 or 5 times. Which took it out of, in his mind, that he couldn't downward depart.
Absolutely, and what he did say, though, is that he didn't have the law that supported him to be able to downward depart, and that's where I argue that the difference was. His reorganization of words saying that he first might not have agreed that it was an isolated incident, then reworded his answer to say, I don't have the law to support that. If I did, I would.
Right.
And what I'm arguing...
Clearly, he was trying to protect your client from a reversal by this court, and then coming back for resentencing and, maybe facing a lot more time, but it seemed like.
Absolutely, and in fact...
It seems to me it was clear that he said, this is not an isolated incident, which you got to have, right?
Well, in this
to downward depart?
Absolutely, you have to have those 3 mitigating circumstances, 2 of which were not objected to by the state, and that was Mr. Ramirez did have remorse, and that Mr. Ramirez did not at that time
unsophisticated?
Was not sophisticated.
It was the isolated incident that troubled the judge, it seemed like to me. From reading the record.
Absolutely, and that's why I started off this morning, Your Honor, by saying that it's really a difference of 2 days. On the record, yes, there was a statement that there was 10 or more times within some sort of period of a year. However, there was a language barrier, and that was addressed, that the officer specifically asked Mr. Ramirez, sir, could it have been 10 times? His response was, sure, it could have been anything, but in my opinion, this is the number of times between 5 and 6, and the victim at the time of the sentencing hearing did substantiate it was about 5 times as well.
Well, and the parties didn't, they didn't give the judge really a hard number. I think there was an exchange between Judge Lubit and the prosecutor and even the defense, and nobody said, no, it wasn't less than 10 times. The number 5 was thrown around, the number 10 was thrown around, and I think the judge even asked, could it have been more than 10, and there was no answer given to him. And also, Judge Lubit's very experienced trial attorney in criminal matters as well, and it was very clear to me that the sentencing entirely focused on 921.00262J, and that was the entire focus of it. He asked the parties, give me something to go on, how are you going to satisfy J? And from my reading of the transcript, and obviously it's the words on the paper, but there wasn't a whole lot given to the judge at that point. He had something between 5 and 10 and maybe even more than 10, and nobody responded to that.
Well, the response, Your Honor, was on the record that the 10 was in error. I believe it was on page 9, in the record of page 90. I'll have to verify that. I apologize. I'll be looking through that while I argue. But in fact, what they said was that it wasn't an issue with the officer questioning, and it was a language barrier. The fact that 10 was thrown around was actually a number given by the officer, not my client. He never specified it was 10 or even greater. At the time, there was a translator, and there was a little bit of a delay in a response at certain areas, but it was clear by my client's statement on the record, and again, I'm going to look for that page number for you, that it was not 10. It was clearly not 10. It could have been 5, it could have been 6. But the reason, again, Your Honors, was why he said it could have been 10 was because at that point, he was looking to be cooperative. And that was also another argument made in mitigation. While, yes, we're focused on the section of the Florida statutes that Your Honor Wallace had illustrated, there were significant other reasons. But again, focusing on that isolated incident and using the competent substantive evidence that was testified to by both the but the victim in this case, as well as the defendant, around 5, we're looking at a case that State versus Merritt in this court, Your Honor, 714 Southern 2nd, 1153, where this court actually said in a sexual, lewd, and lascivious case that 3 times within a period of time was isolated. And that was the argument that I was making. And the judge didn't believe that he had the grounds, not because necessarily only that he didn't believe it was an isolated incident, but that he didn't believe the law would support it, because maybe we didn't have a specific number, and the only number testified was between 5 and 6 times at the sentencing hearing by, again, both the defendant and the
I
victim.
didn't find anywhere in the record it said between 5 and 6. I found in the record stated multiple times between 5 and 10.
I mean, I think the problem is the judge made a factual finding at the end of the day that it wasn't an isolated incident. I mean, we're kind of stuck with that.
And the only reason why I would...
What's the standard of review? I don't think we're dealing here with a case where the judge made an error of law thinking that there was just no way that he could downwardly depart. I think he listened to the evidence and testimony, made a decision that this was not an isolated incident. Right. If it was an error of law, we would have a de novo standard of review, and we would look at the law and say, well, an error was created, we could send it back for redetermination. But if he makes a finding and there's competent substantial evidence to support the finding, our standard of review is abuse of discretion, right?
Yes, according to...
He abuses discretion then,
in
this particular case, in refusing the request for downward departure sentence.
Well, in this case, that I would argue that it was based on error, that he did not have the discretion.
Well,
I think...
I mean, it looks like this court has jurisdiction on downward departures because it is discretionary with the judge, obviously. That one is the judge, as you point out, doesn't think he has the ability to downward depart. And 2 is if he, on the evidence that he makes a mistake as far as, or he or she, it's not the weight of the evidence, but there's an evidentiary issue or a factual finding that's not based on the evidence. But that seems to be it's a limited jurisdiction for this court to even look at a downward departure when it's denied. I mean, it's kind of like, and that's kind of where we are, I mean, it seems to me.
Well, what I was arguing in this particular case is in reference to State v. Murphy, is that the standard of review in that particular case is abuse of discretion. And in fact, what the first step is involving is whether or not there are valid grounds to depart. And whether the judge said, I'm not sure if it was an isolated incident or not, went further on to say, I'm not sure that I have valid grounds to depart. And when he did that, the fact that I would argue, and defendant would argue in error, said that he did not have valid legal grounds, changed that from a factual argument of was it isolated or not to whether or not there's case law supporting.
I think you just have a dispute with the judge's interpretation of the evidence that was presented. And if that's the case, and we find that there's substantial competent evidence to support the finding, I mean, I don't see how we can say that there is an abuse of discretion here. This is not a legal ruling. This is a discretionary ruling on the part of the judge. And it's difficult to overturn those, really is.
And the only reason why I argue in this case, again, Your Honors, respectfully, is that he actually stated on the record that he no longer had discretion, although he wanted to. So had the judge said that I don't believe there's a factual basis that supports an isolated incident and therefore I will not depart, what he actually says is there's no law that supports me being able to depart.
I mean, it seemed clear he was concerned, about a downward departure, that he was going to get reversed. He mentioned a case that he argued in this court. And he said like 75% of the time, this court has reversed downward departure. And, it seemed, and he was concerned that if that happened, your client really could have some problem,
And in fact, off the record,
Resentence.
and on the record, Judge Lubitz said if this were to come back, he would be the one that would handle it personally.
Right. Well, but he kind of said, wasn't there somebody else who was going to take over that division or something?
They were. It has since been, I believe, a couple of other judges.
He was very concerned about it. But it's clear to me that he just found, he was stuck on an isolated incident. He didn't think it was. That was his problem. That's why he said, I don't have discretion, because it wasn't an isolated incident. There's no basis to downward depart. So he gave him the low end, right? Bottom, yeah.
Right, and I would argue that there's, in the State v. Murphy case, that was a similar argument, that the judge did not believe they had...
They thought three, this court said three was could be an isolated
Do you have any
incident.
questions of the appellant? Do you have any questions of the appellee, Judge Jacobus?
No.
Okay. Go ahead and finish up your argument.
And again, I would just like to argue and reinstate that we are talking about the judge changing the vocabulary of him saying that he did not feel that it was not just an isolated incident, but that he was legally bound to not be able to depart. So what I'm arguing is that during the course of the argument, the judge did change a perspective and opened it up to the fact that he didn't believe that there was case law that would support the argument of the isolated incident. And quite frankly...
You all argue that case that said three was isolated, right? He knew about that.
He did.
Yeah.
He did, but I would argue that his interpretation of the difference between we're talking 2 to 3 additional times in a perspective of, in comparison to that case, the defendant in that case was 25 years old, and in his isolated period of life, this was a rarity and a non-usual circumstance that happened in a small period of time. My client at the time was 48. So if we look at the perspective that this had never happened before, it had never happened after, it stopped and started on his own volition, as well as the statements on the
You made
record.
all those arguments to the judge, I think. I read that.
I did, and when he argued that his hands were tied, that's where I felt we had the opportunity to speak to your honors at this point, to say that his hands were not tied. In fact, it was isolated in comparison to the case that was reviewed here in the Merritt case.
All right.
And at this point in my argument, I'm assuming that your honors have made a decision or a finding, but I would argue that this should be sent back to the court for them to be able to determine that they did have the ability to downward depart, that the incident was isolated, and that, in fact, in this particular case, when the judge changed the statement that he went from a fact finding to a legal finding that there was no ability, according to the case law, for him to downward depart, that's where the doors open and the opportunity to appeal and to come back with the ability to direct the judge that he had the ability to downward depart based on those differentiating numbers would rule in this particular case.
We don't have any questions of you. We don't want to deprive you of anything you want to say, but that's up to you. Pardon?
If I could just have a few moments.
Sure.
Okay.
Since there aren't too many questions, I won't bring up everything. May it please the court, Marjorie Vincent Tripp on behalf of the state of Florida. I'd just like to emphasize the lack of authority that it is the state's position that this court does not have the authority to review the denial of a downward departure sentence. The statute clearly states that a defendant can appeal a downward departure only if the sentence is below the lowest permissible allowed by law. And in this case, that didn't happen. Your honors correctly recognize that the judge made a factual finding that the facts did not support this being an isolated incident, and so therefore not only is there a lack of authority for this court to review the downward...
I don't know that I accept your argument that we may not have jurisdiction. I just think that it's a difficult
Well, it's
task.
limited review, I think.
Yeah, I mean, it's difficult for us to, based on abuse of discretion standard, to say that in a case like this, the trial judge abuses discretion. So we have to kind of, as Judge Jacobus just said, kind of limit it to that. I don't know that I buy your argument about it.
Well, Your Honor,
Jurisdiction, but anyway, that's neither here nor there. I mean,
yes,
it's-
I understand, but the statute clearly does state, which is section 921.002, that a defendant can only appeal if the sentence is below the lowest permissible sentence, and we just don't have that here. And Your Honor, finally, as Judge Jacobus did recognize, this was a factual finding that the court made. The court had no misconception about what the law was. The court clearly stated it was a valid legal basis that was required. So in respect of all that, we would request that the court affirm.
Okay.
Thank you.
You've got a couple of minutes left if you want to use them. It's fine.
And again, in the first and the second, it was determined that a review of a denial of a downward departure would be appropriate if the judge believed in error that he did not have the ability to depart. And in this particular case, I would argue that he did not believe he had the ability, not just because there was a factual issue, but because there wasn't a legal support for that. And we were talking about numbers.
Told him that. I mean, you said, Judge, here's a case in this court that says 3 is isolated. I mean, he knew that.
And I would argue that it was his misinterpretation of that law that
Well, I
would
mean,
bring
he
us here
thought
today.
he thought in your case, this case, that it wasn't isolated.
And we would again argue that it was competent substantial evidence that was presented on the record of that number. And I keep bringing it back to that number, but we're looking at the difference between a significant prison sentence and a probationary sentence, which in this particular case was what the victim was asking for. I know that's not for this court to consider, but the ability for this court to determine whether or not the judge can be ruled as far as having discretion on a downward departure is two things. Number one, if the court applied the right rule of law, and if that competent substantial evidence supports that, and that's State v. Murphy. And we didn't have both here, which opens it up against government's argument that this court does have the discretion to do so. And we argue strenuously that those numbers that we talked about were not substantiated to an exact number because of the length of time so long ago. It was 7 years prior to this case being brought to court that this was even at issue. And the family was seeking counseling at the time in order to come together again in support of, number one, the victim and the defendant reuniting and being a cohesive member of the household. The defendant left the house on his own volition. And what we're saying is that this was an isolated incident in that, number one, it's never happened before or after. Number two, in his 48 years, nothing like this has ever occurred. He has no prior history. And number three, although it is within a year period of time, in comparison to 48 years, that is significantly small, as well as the number being 5 and this court's determination in another case of it being 3. We would again argue that it be reversed and sent it for a downward
Your
departure.
time is exhausted. Thank you.
Thank you.
Thank you.